Greetings, my name is James Bell. I'm the president of the law offices of James A.H. Bell, PC, a professional law corporation. This segment will discuss with you the propriety of all criminal court action throughout the entire state of Tennessee. Once an individual is either have their case presented to a grand jury directly or after a preliminary hearing, the grand jury will return what is known as a presentment, which means it went straight to the grand jury, or an indictment, which means it came from the preliminary hearing. That will set out the specific statutory violation or statutory scheme which you are alleged to have committed. Some indictments have one count, some have as many as, I've seen them as many as 150 counts. Don't be overwhelmed. That is just a charging instrument or the means by which you enter into the state criminal court system. Your first appearance will be in criminal court will be the arraignment, and there you'll be called upon by the judge, the criminal court judge, to enter a plea, and generally one enters a plea of not guilty at the arraignment. They'll set the case for trial. You will tell the judge you've been advised of the charges against you, and your attorney will appear on your behalf. Again, if you cannot afford an attorney, this is the stage where one might be appointed to you under certain conditions. Once you are arraigned, they'll set a time for discovery. Discovery is a magical word because discovery of evidence in criminal cases is limited to Rule 12 of the Rules of Criminal Procedure and Rule 16 of the Tennessee Rules of Criminal Procedure, and the ingenuity of your lawyer in means and methods by which to discover the evidence against you, if any exists. Our office uses a trained investigator that's on staff with law enforcement experience that's been through the academy, and will be digging up facts to find in your favor that will assist you in your defense. One motion that we may file with the court is a motion notifying the state of an affirmative defense, which I'll discuss in another segment. There are certain defenses that you must announce to the court that you intend to rely upon. Defending these cases takes ingenuity, experience, if you're going to go to a jury trial. The next stage of the proceeding is a trial by jury. A jury is composed of 12 citizens, and they will receive the evidence. The state must prove to the satisfaction of the jury, which is the fact finder, all the evidence necessary to convict. And that evidence, that standard, is proof of guilt beyond a reasonable doubt. If there is any reasonable doubt that exists in the case, by operation of law, you should be found not guilty. And that would result in an acquittal. However, if a jury returns a verdict of guilt, then there is a conviction and you have a sentencing hearing. The sentencing hearing in Tennessee is a statutory scheme that was developed by the legislature in 1989, and they have divided felonies in classes, from A felonies, your most serious cases, the E felonies, your less serious cases. Misdemeanors are broken down likewise into A, B, and C misdemeanors. A being a very serious misdemeanor like drunk driving or simple possession of narcotics. B misdemeanor could be reckless driving, and C misdemeanor would be something like speeding. A felonies are your serious crimes, sexual crimes against children, rape, statutory rape, aggravated rape, murder, and the like. B felons are your theft over $60,000, for which we defend a great deal of individuals accused of those crimes. The judge will make a decision on the sentence, and it's at that point that you will begin the appellate process. Thank you very much. If you have any question about the entire criminal justice system, from arrest through trial or even conviction, please contact the law offices of James A.H. Bell at 865-637-2900. Thank you very much.